I'm Corey Washington, and this is Manifold. Steve Hsu is away this week. Our guest today is Barbara O'Brien. Barbara is a professor at Michigan State University College of Law, where she teaches classes in criminal law and criminal procedure. She is also currently the editor of the National Registry of Exonerations, which collects, analyzes, and disseminates information about all known exonerations of innocent criminal defendants in the United States from 1989 to the present. The registry provides a virtual home for exoneration stories and also an accessible, searchable statistical database about the cases. Today we'll be speaking with Barbara about her work with the National Exoneration Registry, new developments in the fight against wrongful convictions, and how race and class affect the likelihood that a person will be wrongfully convicted, and how long that person will spend in prison. Welcome to Manifold, Barbara.
Thank you for having me.
How do you define a wrongful conviction?
Well, we document exonerations, and an exoneration is a type of wrongful conviction. And sometimes we use the term wrongful conviction interchangeably with a false conviction, but you could think of a wrongful conviction as much broader than that, to include any case where somebody was convicted of something that was more serious than what they actually did, or convicted without proper process. But when we talk about wrongful convictions in this context, we really do mean somebody who is actually innocent of the crime. Either there was a crime and somebody else did it, or there was no crime at all.
So wrong guy, wrong gal.
Yeah, in many of the cases it is.
Or no crime, perhaps.
Sometimes there's no crime. In fact, we have quite a few cases in the registry where there just wasn't a crime.
So, this is an issue that actually goes back centuries, as I'm sure you're aware. I think some of the first laws designed to prevent wrongful convictions involve cases where actually someone disappeared, and I guess they just sort of moved away. And at one point in time, I think the original British case, 3 people were hanged for it, and then the guy showed up.
Yes, actually, we do have our database begins with exonerations that occurred from 1989 on. But we have another database that tracks historical exonerations that go back as far as we can find out about in the United States. It's not as comprehensive. It's a lot harder to find records about that. But in some of those cases, the victim will show up at their funeral, and before the person could be executed, they were exonerated. So we do see some of those cases in our pre-1989 database.
And this led to laws that required a body actually be found, I think.
Yeah, those rules, I don't believe they're universal, but that's a pretty common rule that, and at the very least, as a practical matter, it's very hard to prove a murder without a body. I
don't want to get sidetracked on this, but I do think it's interesting that you brought up the fact that there's a difference between wrongful conviction and exoneration, because, I think there's clearly a large group of people who are exonerated, but it sounds like there's also even a much larger group of people who may be convicted of something. They may be a little bit guilty, maybe slightly involved, but convicted of something far more serious, and they're never exonerated, and they're often never given clemency or not have their sentences reduced. Are you worried that the focus on exonerations may basically cast a shadow in a way, or at least lead to a lack of attention on this broader range of cases?
Well, so that's correct. I mean, there are, if you think of exonerations as a type of wrongful conviction, but there are the kinds of wrongful convictions you were referring to where someone was convicted of a murder when it really was a manslaughter, or something along those lines. I think there's sort of two ways the focus on exonerations it can go, and maybe both can be true. That the focus on actual innocence, like pure innocence, might make people less sympathetic to the cases of overconviction, which I think is a huge problem, particularly overcharging that can lead to very serious convictions for something that might have been, really should have been a lesser conviction. So that's possible. But on the other hand, what I think you see happen is as people get interested in the phenomenon of false convictions, they're sort of exposed to all of these different ways that the justice system is failing, whether it's by, mandatory minimum sentences that lead to these draconian outcomes, or cases where people are sort of shuffled through the justice system, sort of assembly line justice. I mean, it really does sort of highlights it brings in stark relief these problems that are really salient in the cases of false convictions, but are actually undermining the fair administration of justice at all levels. And I think you can kind of see that. I mean, I do follow a lot of sort of the popular press on false convictions. And what you see are the sort of the people getting interested in this idea that somebody gets convicted of something they didn't do, but they're also then really interested in the idea that somebody gets in the system and then they have a probation violation and then they can't get out of the system. I think about a good example of that is, Serial Season 1. Everybody knows this case. And that a lot of people think that is a wrongful conviction case. Serial Season 3 is about the justice system looking at it sort of through the lens of like one courthouse and just all the different stories that happen in that courthouse in Cleveland, Ohio. And those are not necessarily cases of false convictions, but it sort of highlights the uphill battle people face. Maybe they did something wrong, but then, they get brought into the system and they miss a court date. And the next thing you know, there's a warrant out for them and things just sort of snowball and get worse and worse. It's going to be a lot of the same audience who listens to Serial Season 1 is going to listen to Serial Season 3.
Yeah, I think there's been a lot of interest these days in kind of basically looking back over our sort of fairly severe policies on crime and drugs of the past 30 years and realizing exactly people are overcharged for crimes. And once you get into the system, it's very hard to get a job once you get out. And then you're kind of you're essentially given a kind of mark for the rest of your life that makes it really, really hard. And it seems like there's at least an inclination now to look at a bunch of those convictions and maybe wipe them out or in many cases reduce them.
Yeah, I think of exonerations and interest in wrongful convictions as sort of a gateway to these other issues. And, one big development in the last decade has been prosecutors' offices in mostly major metropolitan areas creating conviction integrity units where they'll actually put prosecutorial resources and police resources into revisiting cases where there's a plausible claim of innocence. And there's talk in starting sentence review units. And some conviction integrity units actually don't just stick to the kind of wrong man or false conviction cases, but they're interested in reviewing all sorts of cases where there's overcharging or over-sentencing.
Yeah, I recall, I think the first prosecution integrity office was started in Texas, wasn't it?
I believe so.
Which is sort of ground zero for both death penalty and wrongful convictions, and perhaps wrongful executions too, as we may get into.
It's so interesting because on one hand, Texas is, it's pretty law and order place. They have a death penalty and they use it. But on the other hand, they also have one of the best compensation systems in the country for wrongfully convicted people.
We've about the worst here, don't we, in Michigan?
It's no, I think there are places that might be worse. Actually, there are places like Pennsylvania that doesn't have any system in place, but they're working on that there. And Texas has, and these were in reaction to cases of just really stark injustice. Has more liberal discovery rules than other places do. You do see this happen in cases where just sort of like a really high profile, terrible crime can lead to a new criminal law based on it, Megan's Law or something like that. The same thing can actually happen with criminal justice reform. So the Michael Morton Act in Texas was passed in response to a case of wrongful conviction where Michael Morton spent more than 2 decades in prison for murdering his wife, and the state and he didn't do it. State had hidden all sorts of evidence that implicated another person.
So straightforward Brady violation?
Oh, yes. Yeah. Really egregious Brady violations.
We should stop at this point and define Brady violation.
Yes, good idea. So Brady versus Maryland is a Supreme Court case in which the court held that the government is required under the Fifth Amendment to disclose to the defense any evidence that is both exculpatory and material. How can it be exculpatory without being material? Well, so there's a lot of problems with the materiality component because because it's always a judgment made in hindsight. And so the judges are sort of deciding, would this have made a difference? But exculpatory doesn't mean that it's, dispositive, right? Exculpatory could be they talk to a witness, they have eyewitnesses, and they talk to one witness who describe the perpetrator very differently than the other witnesses, and they don't. Or they get a lead on another suspect and they don't follow it, and they don't turn that information over to the defense. I mean, it's not necessarily a smoking gun that proves the defendant's innocence, but it tends to favor the defense. Or it could be, and it also includes impeachment evidence. So if the witness who's testifying against the defendant is getting a reduced sentence in consideration for their testimony, and the state doesn't disclose that, that's considered exculpatory evidence. It doesn't prove the defendant's innocent, but it's something that it's exculpatory in that it tends to favor the defense. And so in cases where the state doesn't disclose favorable evidence to the defense, it doesn't mean the defendant will necessarily get a new trial or a new sentencing hearing, as the case may be, if the reviewing court does not believe that it was material, that there's a reasonable probability that the outcome would have been more favorable had the state disclosed this evidence to the defense.
That's clearly a really, really sensitive judgment there on probabilities.
Yes.
How accurate they are in making that judgment.
Yes, I mean they have to by definition. It's you're engaging in hindsight and you're looking back and saying, what would the jury have done with this? Or more even more attenuated, you're asking, what would the defense attorney have done with this information? Because once it's turned over, the state doesn't have to tell the jury. They have to turn over to the defense, and the defense is supposed to make whatever use of it they can. And it's also, but as a practical matter, Brady material is by its nature hidden. If it wasn't hidden, it wouldn't be Brady material. So it's just kind of serendipity that you as the defendant would come across it and be able to make the Brady claim.
So the failure to turn over evidence of Brady violation led to this new law in Texas, the Morton law?
It was it was a case of wrongful conviction in which the post-conviction defense team uncovered some really egregious misconduct on the part of the prosecutor that led to Texas passing the Michael Morton Act, which has much more puts a lot more onus on the prosecution to disclose evidence than the Constitution requires.
This leads us to our more general discussion about the causes of wrongful convictions. I think the first DNA exoneration was about 1987. I think it was in England they freed someone. So we had and that's I think was a point in which people really began to focus on wrongful convictions. We had a lot of research since then about what leads to wrongful convictions and exonerations. One of them, I take it, is failure to disclose exculpatory evidence. What are the other leading factors that we know now cause wrongful convictions?
Perjury and false accusation is the most prevalent contributing factor in the exonerations that we see. Mistaken witness identification, forensic error, or even fraud is a significant contributing factor, and just sort of official misconduct of all kinds, whether it be witness tampering, coercive interrogations. It really depends, though. We often talk about the causes of wrongful convictions, and we actually frame it, the registry, more as contributing factors, right? Because it's really hard to say if this hadn't happened, we wouldn't have had the wrongful conviction. There's often any case of wrongful conviction has more than one factor. That's very frequent. But we often think about, well, what are the leading causes or factors associated with false convictions? But it really depends a lot on the type of case. So in cases you don't see too many false confession cases outside of murders, because murders, getting a confession from someone, getting a false confession from someone, if it's the product of really extensive interrogation. I'm not talking about a case where somebody is, for whatever reason, mentally unstable, and they sort of voluntarily come forward and falsely confess, and that does happen. But the cases where the interrogation produces a false confession, those are significant investment of investigatory resources. You're not going to get somebody in the room and interrogate them for 8 straight hours because of somebody broke into a car and stole something out of it. It's going to be a case with very high stakes. So you are more likely to see a false confession in a case that's like a murder case, like in a really serious case, whereas you're more likely to see a mistaken witness identification in a rape case, right? Because you're less likely to see it in a murder case because you don't have the surviving victim to make the identification. You may have other witnesses, but you're less likely to. So in cases of child sexual abuse that result in exoneration, those are frequently perjury or false accusation, and sometimes faulty forensics. So it really does depend on the type of case, the type of contributing factor that you see.
It seems like there's actually an upstream cause in the case of these false confessions because the police essentially develop tunnel vision, become convinced it's one guy who committed the crime and then try to extract a confession out of them. Is that right? They tend to sort of zero in on somebody wrongly and then basically, I don't know, blunt, beat it out of the person or kind of interrogate out of the person. That's my image of how these wrongful confessions happen. It's not that someone's crazy and confesses to it. They're sort of pushed to a confession by the investigators.
Yes, I think that is true. We don't have great data on the length of interrogation. We do keep track of it when we can tell from the materials that we're working from how long the interrogation lasted. But you're right; they do tend to be pretty long. There are some cases where the defendant confesses falsely very quickly. Those are cases usually that involved violence. There are occasionally cases where somebody who has some sort of mental illness might confess. But you're right, that's not the typical situation. It's usually a situation where the detectives really think they got the right person, and they're trying to persuade this person to tell them what happened. But we see all kinds. I mean, we do see some cases, a fair number of cases where physical violence is used. I think out of Chicago, there's a sordid history of that.
LA also with the Ramparts team.
Yeah, and unfortunately, the Ramparts it's hard to get data on that. It's hard to know even just how many defendants were implicated. And the thing is, So
I guess we should back up and give people a context on.
You're right. We should.
So the Chicago case was a series of police officers who were effectively taking black defendants down into the basement of these precincts and torturing them until they confessed. Now, were those mostly murder cases, or were there other types of cases where the police were convinced they had the person and then effectively tried to beat a confession out of them?
Yeah, they're mostly murder cases, the exonerations that resulted from it. It doesn't mean it wasn't happening in other kinds of cases, but as far as the exonerations in the registry, they are almost entirely murder cases. There was another scandal that is sort of still unfolding in Cook County, which is Chicago, involving Detective Ronaldo Guevara. In his cases, he was accused, and there's pretty substantial evidence that he also was abusing suspects more recently. So you would think that after Burge's cases had unraveled, that they always hear the one bad apple, but it looks like that there's a bit of a culture problem in the Cook County Police Department that this has continued to happen. And it's usually there's often a single bad actor who's sort of involved in sort of the common thread in these cases, but they're working with other people too.
Yeah, I thought it was a team in some of these cases.
Yeah. Burge was in charge of a team. I mean, there's another scandal out of Cook County that came to light in the last few years. Sergeant Watts was going to one particular public housing complex, and he was personally involved in drug dealing and shaking down drug dealers as well. And he would go to people he saw. He would just see some usually a guy standing around or walking into his apartment, stop him, ask him where the drugs were, if he had any drugs. And if the guy said, I don't know anything about that, he would say, "You're under arrest," put drugs on him, and framed him. And defendants were complaining about this, saying, the cop planted these drugs on me. But who's going to believe that, right? A few of them went to trial, but most of them entered guilty pleas because that's just not a defense that typically works. It wasn't until the FBI got involved and investigated Sergeant Watts and some of his colleagues, and they caught him on tape engaging in, I think, shaking down a drug dealer, and everything started to unravel. And I think we haven't seen the end of those Watts exonerations yet.
So this leads us into a topic that I really want to get into with you, which is kind of the racially tinged character of many of these cases. It seems like the defendants, the targets in these cases are Black. And I think that's also true in the case of Ramparts in LA.
Yes.
So it seems like there are many areas where there's allegations that there's racial bias in the criminal justice system. And one of the chief empirical questions is whether these disparities remain after you control for confounding factors like rates of offending. But in these sort of large-scale cases of misconduct, it seems that there's very little doubt that the overwhelming majority of the targets are Black. Would you agree with that?
Yes, or Latinx people too. It's it's a really interesting question because in terms of what do you control for. So if you imagine that, you could say, well, the rates of most Black defendants are overrepresented among murder defendants, and so that explains the higher number of Black defendants who have been exonerated of, say, murder. But then you got to take a step back and think, well, if they're victims of the disproportionate murder rate. I mean, in the same way that Black victims are overrepresented among murder victims, the people who didn't commit the crime are also victims of that same disproportionate level of violence. But at the same time, that is different from saying that
That's correct.
They were targeted because they're Black. It is a product of it, and it's not something that they're doing that's causing it.
But you could argue that there's a uniform error rate across racial groups. You make an arrest, leads to conviction. There's some X percentage of people who are going to be mistakenly arrested and convicted, and that could be constant across racial groups. And if you have, say, 50% more Black defendants because Black men are committing 50% more murders, and you find the 50% more being exonerated, you would not be surprised, right? Because it's going to be consistent. But it looks like what you're finding in many of these cases is a far higher proportion than actually the offending rates, suggesting that there's some other factor involved.
Yeah, no, there are definitely other factors, right? It's so particularly in sexual assault cases, if you look at look at the best crime estimates, Black perpetrator, white victim rape cases are unusual.
I think they're about 11% of all cases.
Yeah, they're a small percentage, whereas a much higher percentage of of sexual assault exonerations are interracial.
In half of sexual assault exonerations, eyewitness misidentifications, let's say, Black men were convicted of raping white women. So that's kind of a particular. We actually need the data for how many are exonerated overall, but it looks like in about half case of witness misidentification, it's a Black men accused of raping a white woman.
Right. And I mean, the people are terrible at eyewitness identification. I mean, that's just, people just are across the board, but we're particularly bad at identifying a stranger of a different race, particularly white people identifying Black people. So yeah, that's not the same thing as an overt racial animus, but it is that does explain some of the disparity that we see. But we also, we have lots of cases with explicit racism in it, where people became suspects because they were a Black person in a white neighborhood. They didn't belong there. They stood out. Or it was a Black man dating a white woman, and that's what brought the police's attention to them. And in some even more overt cases of explicit racism.
One of my few encounters with the police was when I was a graduate student in Berkeley. And I was crossing the street, and this police car comes up, stops in front of me, and asks me to come over and put my hands on the back of the car. I do it. I comply, and pats me down, and he says, "Yeah, we have reports of a Black guy who robbed a, I think it was, I mean, I think he said massage parlor, but I think it may have been literally massage parlor. Hard to say. Anyway, yeah, purely on that basis, I was pulled over. And who knows? If I looked more like the guy, maybe I would have ended up handcuffs. I mean, it sort of fits the pattern, I guess.
Right. I mean, and if you think it shouldn't be that surprising that we see these disproportionate. I mean, we see a higher rate of exonerations, that Black people are overrepresented among exonerations than what you would expect. And there's all sorts of, if you start to think about it, you can think of all sorts of things that could be driving it, which is if crime tends to be intra-racial and there's an eyewitness, and the perpetrator is described as a black man is more like, right, they're more at risk of being falsely identified as the perpetrator.
Before we move on, I just want to drill into sexual assaults a little bit because I think it's a pretty dramatic area, if that's all right. Barbara, I believe that in the case of sexual assault exonerations, that it's not just eyewitness misidentification that leads to a disproportionate number of Black men being falsely convicted. There are other factors that go on. Prosecutorial misconduct seems like it, and not just prosecutorial, I guess also police misconduct seems like it plays a role in these cases.
I think that's true. It's part of the problem with studying this is you often don't have the kind of smoking gun as to what the motivation was. We try to be as objective as possible in finding the presence or absence of certain factors. And when there's evidence that comes out that hadn't been disclosed and there's evidence the prosecution had it, then we can call that prosecutorial misconduct. But in terms of their motivations, unless they say something, it's in any one case, it's really hard to say that we can prove that this was racially motivated. But I think when you look at the patterns, even if you can't identify a particular case and say this prosecution was racially motivated, particularly if it's not the kind of overt, explicit racism that you do see in some of the cases. So if it's a case where the defense attorney says you should really take the deal because they're not going to believe you, who's going to believe the Black defendant accused of rape over this nice victim? Or a prosecutor who is maybe, or police detectives who are more inclined to accept a certain narrative because it's consistent with their stereotypes. These are things that are, they're not necessarily going to leave a paper trail. You're not going to be able to sort of follow the decision making and figure out what was driving it. I think we can be confident, maybe not in a particular case that this is what's happening, but that this has to play a part on some level.
And no doubt, we have a lot of anecdotes, and it's very hard actually to assume we have a kind of unbiased sample of these cases, right? So you can pull out cases where it looks like we have evidence of bias. We actually don't know how many comparable cases there are where, say, a police officer effectively had set up a biased lineup for a white defendant either. So I agree it's difficult to get really solid evidence to...
Right, but I think we can also, if we think about it in terms of the context of history and there's a big difference between saying, I am convinced that this person was convicted because of their race versus saying, based on our history and our not too recent past, it wasn't that long ago where people didn't even hide these kind of motivations. I feel very comfortable saying that racial bias contributes to false convictions. The other problem with any study of wrongful convictions, and by that I mean false convictions, is that we only know about false convictions that result in exonerations. We don't know about the cases that the person doesn't achieve exoneration. And so many things, there's so much luck involved in being exonerated. If the evidence was destroyed, you wouldn't believe how many evidence rooms in police departments have experienced floods over the years.
Really?
It just seems like I always run in. I always seem to be reading about that.
Just over.
Yes, the evidence was lost when the evidence room was flooded, 15 years ago. There's so much luck involved in getting exonerated and think about it, right? So imagine your sort of prototypical exoneration is a rape in which the only issue is who did it, right? And you have a victim who identifies the defendant, in a lineup or a show up, and that we learn years later when the DNA is tested that it couldn't have been this person. We know we made a mistake. Here you have a situation where you have an eyewitness who's the victim, who had a very clear opportunity to see the perpetrator often, who has absolutely no incentive to not be accurate. They have every incentive to get it right, and they still made a mistake. So now think about that in context of an armed robbery, where you have the weapons effect, where the weapon that the perpetrator's holding draws the eyewitness's attention away from their face, usually a shorter amount of time to observe the person. But you're not going to have DNA in vast majority of cases to prove that the person didn't do it. So you see far more rape exonerations than you do armed robbery exonerations. But we have every reason to think that the same problems that would produce a false conviction for rape, that also applies in an armed robbery case. And we'll never know. We'll just never learn about it. So the only sample we have to look at, is the universe of exonerations. That's our best proxy for innocence, but it's skewed. We know it has to be skewed.
When it comes to race and sexual assault, one of the statistics I used to quote when I taught the death penalty when I was a philosophy professor is I point out that everyone sentenced to death for rape prior to 1950 in the United States was black. And that was just before they actually, I think they outlawed death penalty for rape. But it shows you, there's been a kind of consistent component, especially involving rape of victims, the race of the victim in the case of sexual assault cases. But this probably brings us to a kind of empirical question. How much do we know about the rates of wrongful convictions? I think we do know we have good estimates in the case of the death penalty based on exoneration, right? Using exoneration as a proxy for innocence. And do we have any? What's the number in that case, and what are the estimates beyond there, if any?
Well, that's $1 million question, right? And because of how little we know about false convictions, because we have to use exonerations as our proxy. Whenever I talk about this, I always start with a caveat that there's so much we don't know, and it's not because we haven't tried hard enough. It's just there's so much we don't know. But you're right. The death sentencing is a really interesting. People who've been sentenced to death are a really interesting population to look at because they get a tremendous amount of scrutiny. Their cases are more likely to have counsel all the way through the process than somebody who is sentenced for even a very serious crime with a very long sentence. So they're not like other defendants in that way. And we do see a much higher rate of exoneration among death-sentenced defendants than we do among other populations. And there's only two possible explanations for that. One is we make more mistakes in death penalty cases, and that we are more likely to catch those errors. And they're not mutually exclusive.
Why would you think you'd make more errors in death penalty cases?
I don't know if we do, but that would be the only explanation. That is one of two explanations for why we see such high rates.
One explanation I've heard is that these cases are just so hot, right, that the police really feel like they've got to solve it. They're going to get somebody regardless of whether they've gotten the right person.
That's right. So I don't know. I think both could be true to some degree. They're not mutually exclusive explanations, but those are the only two possible explanations.
It seems like the second one seems extremely plausible because so many researchers are dedicated to this. I think,
That's right.
You don't, whatever you think about somebody, you don't want them to be killed for a crime they didn't commit. So I think
that's right. But it is also possible that we do make more mistakes in capital cases because if you think about it from the perspective of just, a prosecutor who's trying to make the best use of their resources, if you have a weak case of somebody breaking into a car, you're not going to pursue this case and take it to trial. You might. There are always examples of it, but it's less likely. But if you have a crime heinous enough to be capital, you are going to pursue it if you can, right? Even if there might be some flaws in your case, some holes in your case. So it is entirely plausible that in capital cases, an innocent person is more likely to be convicted just because the same level of evidence in a less serious case just wouldn't be brought. But I do think the more I would speculate that it's most of the difference that we see is due to the greater scrutiny, and that if we applied the same level of scrutiny to cases that did not result in a death sentence, that we would probably have a lot more exonerations from that population as well.
So I think there's an actual estimate out there from Samuel Gross. I think it was was you and Samuel together?
Yeah, and two biostatisticians.
So can you review those findings?
Right. So I Sam Gross at the University of Michigan Law School, along with two biostatisticians, Edward Kennedy and Chen Hu, and we did a study using people who were sentenced to death and looking at exoneration rates among those prisoners sentenced to death, and use survival analysis, which is something that epidemiologists use.
It's a really interesting application of that technique, kind of an inverse application, because...
That's right, because we were looking at the likelihood of being exonerated, and that's a good thing, but usually when you're doing survival analysis, you're looking at mortality, which is a bad thing. So death was... So it was a little bit flipped. It took a lot of getting used to think about that way. And we estimated, looking at rates of exoneration among death sentence prisoners, had they stayed on death row for a certain amount of time, I believe it was 20 years, you'd expect to see a rate of exoneration of 4.1%, because people leave death row all the time for reasons that not due to exoneration. People leave death row because they die of natural causes, because they get their sentence reversed, or they're executed.
So this was, I think, one of the, I hate to say, disturbing implications of this paper, which is that if you leave death row and get sentenced to life in prison, that actually might be worse for you because people stop paying attention to your case. There's a good chance a whole boatload of people who are actually innocent and just serving life sentences now.
I think that's there. I obviously have no idea how many, but I think that there are definitely people out there who have been resentenced and removed from death row, who, had they stayed on death row, would have been exonerated. In part, I think that because the same kinds of, when you're arguing, if you're an attorney arguing for someone who's been sentenced to death that they should get relief, often the legal arguments you make require some sort of reexamination of the evidence, in that was the error harmless. So the weight of the evidence matters in whether you can get relief on a purely legal claim. So what that means is that somebody who has, not a great case against them, they actually, was a close case, they're more likely to get relief on a legal error that doesn't result in exoneration. So the people who leave death row and get resentenced, I think probably on average, those are the people with, on average, weaker evidence against them.
Wow. And so thus more likely to be innocent.
That seems very plausible to me.
So do we have any numbers beyond the 4.1% for the likelihood of wrongful conviction?
There are studies that do similar types of exercises, looking at cases in which, examining, say, DNA exonerations and trying to draw estimates from that. And, it's just incredibly difficult to it's just incredibly difficult to make estimates. The only reason I think that we felt comfortable doing so in the context of the death penalty, and even then with a lot of caveats that it's just an estimate, is that those are the cases where the records are the best. You're most likely to get the underlying records. The opinions tend to be published opinions. There's more written petitions that you can get access to, and also that they get the kind of scrutiny that they do.
You actually have, it's not just internal to the justice system, you have outside groups, innocent projects that take an interest in these cases and do an incredible amount of external due diligence. So it's sort of an external actor in some sense. It's driving these changes.
That's right. And we call these actors professional exonerators. So they are innocence organizations and also conviction integrity units in prosecutors' offices that are huge drivers of exonerations. And there's been a proliferation of them. I believe when I last looked, there were 56 conviction integrity units in the United States, still a very small percentage, but a lot more than there used to be. There's also, I think, roughly the same number of innocence organizations. There may be some more. But some are better resourced than others, but all of them get more requests for assistance than they can help with. So they have to triage. And part of their triage is just figuring out which are the most likely to actually lead to exoneration. But some of them, it's actually a lot of them have a requirement that you have to have a certain number of years left to serve on your sentence. So
Wow.
They have only so many
if
attorneys to go around.
If you're close to the end of your sentence, they're not going to give you attention, and thus those people likely will be lost.
Now, there are people who've been exonerated even after they've been released, but that's much less common. And if you talk to any of these attorneys, it's not that they think that the person, an innocent person who's only got a year or two left to serve. We say only a year, like that's nothing. It's actually a long time. Or who's actually been released and on parole. It's not that they don't have a lot at stake, and that, if they're innocent, they deserve exoneration. It's just that they have to pick which cases they're going to put their resources behind. And, depending on where you are, if you're an innocent defendant who's been convicted, whether or not you're ultimately exonerated may depend on just, is there a well-resourced innocence organization in your jurisdiction that's willing to help you? That's really, these are factors that have nothing to do with the underlying strength of your claim. It's just serendipity. Just like, if you have DNA, if there's biological evidence that existed that could exonerate you, but it's been destroyed in a flood, or it's just a department that had lousy evidence retention policies. That's totally out of your hands, but that could make all the difference in whether you ever get exonerated.
I recall, just not wanting to waste resources on cases that they perceive as comparatively low value. This intersects with an interesting issue of wrongful execution. Because, of course, innocence projects don't dedicate a lot of effort to trying to figure out whether someone who's executed is innocent, because you can't. They've already been killed. But I believe that there were laws passed, or at least some jurisdictions prevented post-death testing of DNA. Is that right?
I don't know the specifics, but I do know part of it is just trying to find the best place to use your resources, where you can do the most good. But also just legally, like, how do you get into court and say, hey, judge, compel the state to turn over this evidence to get tested when the case is closed? Like, there's no active case anymore. There's just often no legal avenue in which to do it. The state isn't going to agree to it, and the court doesn't have a case before it. So there really isn't a mechanism. It's
kind of bizarre. It seems like, look, clearly it seems like one would want to know.
Yes. Or do you?
Yeah. I guess, yeah, if some people have different interests, they probably don't want to know.
Yeah. We do see posthumous exonerations. We do have some posthumous exonerations in the registry.
People who have been executed, or people who've died?
People who've died. And it's often a case where there's a family member who has fought very, very hard. And often the process has sort of gotten started already. The legal mechanism for doing so, the habeas petition, the post-conviction petition, has already gotten underway. They're a lot less common than you would, but when somebody's been executed, that's loaded.
I was a little bit obsessed with this a couple of years ago, and so I dug into the kind of literature on wrongful executions. There are a couple of cases that really stand out. The Carlos de Luna really stands out. Todd Willingham really stands out. I think there's been a lot of literature written about both cases. There's a real consciousness now. As far as I know, in fact, part of the reason the American population has begun to turn against the death penalty, at least from surveys, people worry about wrongful executions. And so I don't know if these cases have driven it, but it seems like the number of exonerations has slowly seeped into public consciousness as potentially leading to the possibility, significantly greater than zero, that someone be wrongfully executed. So it seems to have affected public opinion, judging what people tell surveys.
I agree. I think this kind of gets back to your question at the beginning when you asked about, is the focus on actual innocence sort of detracting from some other justice issues? But if you think about it in terms of the death penalty, I mean, imagine if it, 4%, right? So just go with the 4.1%. That's an unacceptably high number. If that were true, let's even say we doubled it, right? And we said it was, 8% are actually innocent. It's still most people who are convicted and sent to death row are actually guilty. The danger that comes from executing an innocent person often makes people say it's not worth it. Even if 9 out of 10 are guilty, it's absolutely not worth it. But it also is it's just we can't do it right. Let's just not even. It's not worth it to have this penalty. We can do without it. There's lots of states that don't have it. They're not falling apart.
Yeah, the numbers have been going down over the past few decades.
Right. So a number of different things I think are driving that. One is I think people are public opinion is shifting on the death penalty. It's not as strong as it used to be, and part of that is I think driven by the innocence movement. The fact that people are recognizing that the errors are more common than what we would consider acceptable. And also, crime has gone down. And I think, that's obviously a big part of it. The quality of representation in a lot of places is improved dramatically.
Yeah, I think this is actually kind of undiscussed component of exonerations. Someone once said, I think many people have said that the people who are falsely convicted are almost always poor and almost always have a public defender. And so it looks like if the equality is going up, you probably would see fewer wrongful convictions. Is that because of these external groups coming in?
Well, yeah. I mean, I would say, we don't have financial information on the exonerees in the database, but yes, suffice it to say that we have our share of white collar criminals who are exonerated. But for the most part, it does seem to be people of lower socioeconomic groups. It's also hard to assess the quality of their representation based on the information that we have. In death cases, I'm thinking about North Carolina, which is a jurisdiction I know best in terms of the death penalty. There were cases in the 90s and the 80s where somebody would be appointed. They wouldn't be a public defender. I mean, a public defender, at least that's what they do all day, right? And if they are well-resourced enough, you can often do no better than a public defender because that is all they think about all day long. And they're really well-trained.
But the key caveat there is well-resourced.
Exactly.
Right? Often these public defenders have 40, 50 cases on their docket.
Oh, more than that. Way more than that. But there would be cases where somebody who his only experience, he'd been a lawyer.
It's like a tax lawyer or something like that.
Done real estate deals, had never, and they don't appoint more than one lawyer. It's just one lawyer for a death case. And, those
death cases are very expensive to actually to investigate.
But they wouldn't actually put the resources, the court wouldn't, approve funds for an expert or proper investigation. And so that's really like North Carolina has an indigent defense commission where, they mandate that there have to be two attorneys to represent somebody charged with a death case. They, have to have a certain level of experience. There's money for experts. So, you see the quality of representation go up.
So that's changed, do you think, by statute in general or just by kind of public pressure?
Well, the public pressure is what leads to the statute. I think that it's not universal, but it's much more common now to see more rigorous defense standards for at least capital cases. I think when I think about all the the limits of exonerations as a proxy for innocence, it's the best proxy we have. But where we're really missing is in the low-level misdemeanors. We have absolutely no idea how many of those cases are false convictions. We know we have some in the database, but when you think about the under-resourced either public defender's office or I think even worse are the court-appointed attorneys who sort of take it on a contract basis who, have very low caps on how much they're allowed to bill for a particular case. There's no resources for investigation. There's very little time to do any consultation. And the stakes are seen as very low. So people are encouraged to plead and they say, then you'll be done. You don't have to serve any time. But there's all these collateral consequences that they suffer once they've been convicted, even of a misdemeanor. I think that's the real great unknown. I mean, I think of it like the ocean, how much do we actually know about life in the ocean? That's the deep depth, right? That we don't know. I know it's bad. I believe it's really bad. The rate of false conviction among misdemeanor defendants is high, but we're going to miss most of it.
Your paper with some of the gross actually connected with the recent discussion of sexual assault because you see this number quoted consistently, which is about 8% of sexual assault accusations are false. And having read your paper, it's quite clear to me that people have no idea what...
We don't have any idea.
I think someone actually looked at that figure and they could not trace it back to a source. Actually, there was a source, but the source basically had no evidence. But yeah, the only way to figure out whether someone's telling the truth or not is actually to follow the cases to the end, have a large sample, and see how many are exonerated. Mm-hmm. That gives you basically a lower bound on it. But that's never been done actually for sexual assault.
And we get asked this all the time, about they'll look at how many cases involve perjury or false accusation, and they'll look at sexual assaults or rape cases and say, well, look at all these cases that involve perjury. But it's often, a police officer lied about some aspect of the case, and we would count that as perjury or false accusation. But in terms of, victims coming forward and lying, saying this happened when it didn't, we have cases like that does happen. But anybody who claims to know how often or what percentage of them are is just... Basically, what I can say confidently is that it has happened. It's some number of cases, but I would never venture a guess as to how often it happens, based on exonerations anyway.
So I want to turn now to some of the possible solutions to the problem of wrongful conviction. So, technology's changed a lot since we've realized this is a large-scale problem. We now have DNA testing. There's a lot more cameras everywhere. And so it seems like right now there's actually something of a conflict between people who are working against wrongful convictions and civil libertarians, right? It seems like one of the best ways to reduce the rate of wrongful convictions would simply be to have every male on the planet contribute DNA to a database. And therefore we'd be able to tell whether someone was wrongfully convicted of rape.
No, not necessarily. I mean, I hear what you're saying, and I don't disagree with some of it, but if I'm accused of a murder and there's blood left at the scene, you don't necessarily have to know whose blood it is to know it's not mine if I'm the suspect, right? I just need to be excluded. Yes, to then catch the person who left the blood at the scene, you might want that.
That's right. I think, but often having a clear perpetrator can take the heat off someone who might be a suspect, right? So if there is, say, blood at the scene of some kind, it's not mine. You don't know whether I've got a collaborator or something like that, but if you can trace it back to me, and then you find out, hey, I'm been accused of these other things also, that definitely takes the focus off the person you may be thinking about. It just gives you more data, right?
You're right, it does.
So it seems like there is...
I'm just saying I don't think it's quite as stark. And I think your camera issue is, there was an officer in Baltimore who turned off his body camera to go put drugs somewhere and then turned it on and said, oh, look, I found these drugs right where the defendant was. But he didn't realize that actually it kept recording for it.
Oh, really?
He wasn't actually hiding what he thought he was hiding. So it was exactly the kind of thing that, defendants say he planted the drugs. And you say, come on, he didn't plant the drugs. Well, actually, we have it on camera. He did. Cell phone data is another one. I think you had mentioned before that, I know that anywhere I go, somebody could figure it out if they had access to my phone because I have my phone with me all the time.
So you see,
but these things are happening anyway, right? So these, the surveillance. I think about it. In some parts of the world, anywhere you go, you're going to be on CCTV.
A friend of mine in Beijing claims that you can't commit a crime in Beijing and get away with it for more than 24 hours.
But a lot of this is due to private actors, right? This is, I mean, it's sort of a bigger question than any sort of criminal justice reform can answer. Just a question of, do we avail ourselves to this?
Have you seen any benefit from this increased amount of data in exonerating people? Have you found, say, an increased number of people exonerated through cell phone data or even cell phone footage or CCTV? Or the increasing, amounts of data available in DNA databases. We're now seeing cases where people are being convicted through DNA databases, but I'm going to assume that you're going to start seeing a few cases of people being exonerated once you actually track the person down.
Yeah, I think you're going to see. I think it's going to take a few years for us to start to see that, because exonerations take a long time. Also, as the technology is available, then it's available at the trial level, and central to our definition of an exoneration. For most of our exonerations, unless it's a pardon based on innocence, most of our exonerations are some new evidence that wasn't presented at the original time of trial. I think part of the problem with some of these technological advances is that they're maybe not as solid as we think they are. So the cell phone tower ping, your cell phone pings a certain tower, and people think that means you had to have been there, but actually, it's much more complicated than that. It can ping multiple towers, so it's not as probative as we
As the issue in the
thought
serial
it was.
case, actually.
Exactly.
All this will seem to be changing as bandwidth increases. It seems like you're probably going to get more granular data on people's locations. My personal theory, let me tell you my personal theory, and you can tell me, is that, look, over time, not only do you have cell phone data, you're going to actually have wearable clothing. So be able to tell not only where somebody is, but actually what they're doing at that point in time. So you'll know from my, synthetic, Wi-Fi connected shirt whether I'm, running very fast or whether I'm moving. Once you get data at that granular level, that may be a boon. Actually, you essentially accelerometers on your
It is
iPhone.
incredible how much data I have allowed about myself. I'm like, well, I don't care if somebody knows how many steps I took today, but...
And my guess is for defendants, right, if there's a class issue and people don't have access to technology now, they may have access to it in the future, even if they're lower socioeconomic level, and thus will have data about people who are probably more likely to be accused than you or I of these crimes, and that may be potentially exonerating.
Yes. On the other hand, I was just reading a case today that we're about to post where a person was he was convicted of a murder from the mid-1980s. I think it was 1986. And he just got exonerated this month. And he had 4 or 5 alibi witnesses that he was in a different city at the time. But the jury didn't believe it. They believed the person who said, he was my cellmate, and, he was in jail on another charge, and he confessed to me. So, I've seen enough cases where...
But presumably technology would override, I would hope.
I don't know.
Cases.
I mean, I think that if you have... I've seen enough cases, and not always the case, right? Every case is a little different, but and every jury is a little different. But I've seen enough cases where people had, multiple fairly disinterested alibi witnesses who could corroborate the time they were with the defendant because, they went to a store together and they have the receipt from the time they were there and what they bought, and yet somehow they get convicted. So it does happen. I think about that in the case of the Central Park 5, which is an interesting case for many, many reasons.
So please remind, I think most people are generally aware of it, but can you give us the background?
Over time, my students have been less so. But now with the movie, they tend to know it. Central Park 5, there was a jogger in New York in the late 1980s, I think it was 1989, who was viciously attacked and raped and beaten. And there were 5 young boys. I mean, I think they ranged in age from maybe 15 to 17, but pretty young, who had been in the park that night and were taken in for questioning. And they, I think most of them, I don't think all of them did, but most of them gave statements that they had participated in the rape and very vicious beating of this woman. Before trial, the DNA was tested and it excluded them. It was one person, but they still got convicted. They still got convicted because on the basis of their confessions. And it wasn't until, I guess this goes back to your point you were making before, somebody came forward and said, I'm the one who committed this crime, and it was his DNA, that they were exonerated. So even in cases where you think that something is pretty dispositive, at the very least reasonable doubt, doesn't always work.
I think a lot of factors played into this one. Again, a high-profile case, police felt like they had to solve, and they had, potential perpetrators who were not in very high value socially from them.
That's absolutely right. And I remember, because I grew up in upstate New York, so we would, it's a pretty different world from New York City, but we would get the New York City papers and get the media from there. And I mean, that case was just the biggest story. It was just such a horrific attack on this woman. Nobody expected her to live or recover. She did, thankfully. And you had confessions, right? I mean, you had confessions from these boys. We know more now. We know how somebody might confess to something they didn't do, and we know that the kinds of people who are likely to confess to something they didn't do, a big factor is youth. They were young. I mean, they were, I think maybe as young as 14.
I think that's about right, yeah.
Yeah.
I think this was one of the first forays of Donald Trump into politics, when he, quote-unquote politics, when he took a, 2-page ad out in the New York Times, basically.
And sticking by it, right?
He refuses to admit he's wrong, yeah.
There are some players from that who are absolutely convinced that, okay, Mateus Reyes, the person who confessed to doing it and it was his DNA, they think, well, they must have participated as well. Even though their statements didn't really add up together.
They didn't even know where she was, actually. They had no idea where the crime was committed.
And, the drag mark, I mean, it's horrible, but you have to think the things that you have to think about in assessing the credibility of a confession. But, the way the vegetation was at the time, it didn't look like a group of 6 boys, which would have been 6 people with him. Or at least 5 if he came along later, which is one of the theories that the boys attacked her, and then this guy just kind of stumbled across her and then attacked her again.
This case, although it doesn't fit the technical definition of a kind of group conviction, it feels like some of the other cases discussed that have racially biased angles. So we've seen cases over the past 30 years where, in the case of, say, drug deals, where large numbers of people are convicted of drug dealing, and they're almost always Black or Latino. Mm-hmm. I'm not really aware recently of large numbers of white kids being convicted falsely of rape. So this feels like very similar to these kinds of drug cases. There are a couple of very large cases. There was one in, I think, in Texas, where basically a kind of informant got about 39 people convicted. And then there are similar cases in L.A.
And Baltimore, Philadelphia, there's some group exonerations. Actually, it's glad you brought that up. So the National Registry of Exonerations has thus far focused on individual exonerations, and part of our definition of an exoneration is that it requires some sort of individualized revisiting of the evidence. And the problem with these sort of mass or group exonerations is that it's often sort of a domino falls, and then a lot of other dominoes fall. So I think about the Massachusetts cases where the lab tech was dry labbing, which means that they said they were doing the tests on the drugs, but they weren't. And then, huge swaths of convictions are vacated. Those aren't an individual revisiting of the evidence in a particular person's case. So we've never really known quite how to fit them in. So they're not in the registry. But we are launching a group exoneration part of the website, hopefully in the spring or early summer, to look at these. Because if you think about it, individual exonerations are really focused on the individual defendant or a few defendants, where the facts are really revisited. But we also care about these sort of more systemic corruption cases that lead to exoneration of a number of defendants. And there, the focus of inquiry is usually on some official actor, right? It's usually a police officer who is discovered to have been corrupt, planting evidence or, fabricating lab results or something like that. So we are going to be devoting some resources to that in the near future.
And at this stage, do you have any estimate on the magnitude of this problem? Is it far small? If you take some of these group exonerations,
some might be a few dozen defendants. If it's, I think, I don't know off the top of my head how many were in Tulia, Texas, which is what I think you were just referring to. Sometimes we don't even have an accurate count of the number of defendants whose cases were cleared. So I think Ramparts is a good example. There in Philadelphia, there have been, I believe, over 1,000 cases have been, convictions have been vacated based on the discrediting of a particular arresting officer. Many thousands in Massachusetts based on the lab scandals there. There's actually 2 separate lab scandals. One was a case of dry labbing where they just weren't, the analyst.
I like that term, dry labbing. It wasn't labbing at all, actually.
No, it's just faking it, right? And then another was a lab analyst who is sort of dipping into the samples that she was supposed to be testing. They're often of a very different nature. The process of exoneration it's really hard to be exonerated. The whole presumption of innocence that you get before you're convicted, and quite understandably flips once you've been convicted. So now, once you've been convicted, there aren't really good mechanisms to revisit the facts. The appellate process is about correcting the process error or legal error, but courts aren't really interested in revisiting facts. So if you discover new evidence, either because the state withheld it or your attorney was ineffective, or just something that wasn't anybody's fault, it just wasn't available to you then, there's not a lot of mechanisms to get back into court. And then there's a tremendous, the hurdle that the defendant has to overcome to get relief is really high, which is why we feel that exonerations are a good proxy for innocence. Of course, we know there have got to be some people who are in the registry who are actually guilty. Just like we know there are lots of people who are not in the registry who are actually innocent. With group exonerations, it's even harder because if they throw out a whole bunch of drug convictions because they never tested the drugs, some of those people did have drugs. We know that, but we just don't know who.
Yeah, I believe, in fact, there's actually a new case coming out of New York State because they found the algorithms used to basically detangle different people's DNA. There's a new algorithm developed to basically tangle different people's DNA from DNA samples. It looks like that algorithm may not actually be as accurate as people had thought. So this is a thing that's been developing over the past, I think it started about a year or so ago.
Wow.
I first read the papers about this.
Yeah, and I think
there's actually proprietary technology built by a company, and there's a black box, and the investigators using this system without having any idea of how the algorithms actually functioned. So they're now revisiting those cases, throwing many of them out.
I would imagine that in those cases, if there's DNA involved, they tend to be more serious cases. And so that there would probably be a individualized inquiry as opposed to sort of I don't know. But
I think they're reopening the case. They're probably not throwing them out entirely.
Right. So assuming the material still exists, you can retest it using accepted methods.
So I think we're about out of time.
Okay.
Barb, but thanks for coming by. This has been a really interesting discussion.